In England, there's a historical right for anybody, you, I, any organisation, to bring a private prosecution, and of course that's something that's considered very important in the English Constitution, something that people have used quite properly in the past, and that's simply what we do. We investigate the matters ourselves because we recognise that if we didn't do it, quite often nobody else would, and then we use the ability to bring a private prosecution to put it before the courts. And in 97% of cases that we put before the court and evidence is heard on them, we achieve a positive result for us. So we believe we're probably doing, a pretty good job. We do take prosecution extremely seriously. It is a matter of last resort when every other way of working with the person has failed or perhaps is not appropriate in some cases. And it is something that is only done after so many other processes are explored, right through from the investigator to their senior officer to consideration by an independent prosecution body, adoption of an independent solicitor to consider it, and then of course the court, who upholds every defendant's rights as well it should. Human rights are respected. The court is that objective arbiter of everything that it hears and will consider that the decision to prosecute was right or wrong, and that's exactly what it's there for. When we look at those, say, a couple of thousand files, I think, every year that come into us for consideration, bearing in mind the hundreds of thousands of calls that we receive, we're looking at applying the CPS test for Crown prosecutors, exactly the same test that the CPS applies. First of all, we're looking at, is there enough evidence to justify bringing this prosecution? Is there a realistic chance of obtaining a conviction in this case? And that's really the legal test. We're looking at admissible evidence, how it was obtained, whether that was fairly obtained, what there is that we can put before the court to show whether the offence was made out. The second question is the much more difficult one, the balancing act, and that's the public interest test. That's a consideration of, is it in the public interest to pursue this as a prosecution? All sorts of factors bearing in mind there. The state of the defendant obviously is one of them, their age, any vulnerability that they might have, but also what is the offence involved? Some elderly people may be in a very vulnerable position in their lives, but you've got to look at what it is they might have done, and whether animals might be at risk in their care, whether they accept what they've done is wrong, whether they might continue to get animals. And if there really is no other way of safeguarding the interests of those animals, then again it might be in the public interest to proceed to a prosecution. One of the most successful outcomes for us would be a disqualification order banning somebody from keeping or being involved in animals in the future. That to us provides protection from animal abusers, if you like, people who think it's appropriate to chuck cats off balconies or stub their cigarettes out on their dog. It's important that they can't have access to animals in the future and do that sort of behaviour. Personally, I've always found juvenile offending quite distressing, because on one level you've got the public interest, which makes it so difficult to consider whether it's appropriate to bring a prosecution. On the other hand, juvenile offending is traditionally some of the worst you will see. It is poking the eyes out of hedgehogs with a pen, chucking the cat off a balcony and filming it on your mobile phone, not just once, but repeatedly going to collect that animal and throwing it off again. It's that very deliberate infliction of very severe harm, often to wild animals, I think, that can be really quite distressing, and that makes those cases much more difficult to deal with in trying to deal with them from a public interest point of view. I think one of the areas, though, that we are really, really delighted with is the Animal Welfare Act and the imposition of a duty of care on people to care for their animals. Just before we spoke, one of my colleagues showed me a photograph from the early 1990s of a Rottweiler kept on a dilapidated balcony I think in Brighton, and it had jumped off and hung itself. In those days, we couldn't take a prosecution in respect of the two remaining animals living on that balcony because it had died instantly and it hadn't suffered. That was the only scope we had. These days, the inspector would be able to advise and assist and escalate their dealings with those owners to the point of issuing them with a warning notice, spelling out exactly what they had to do to meet the needs of those animals. And if all of that had failed, we'd now have the possibility of prosecution available to us for failing to keep those animals in an environment that was suitable for them.